Good morning, everyone. We're here today for oral argument. We're going to begin with a longer argument in case number one. This has three appeal numbers, 22-2674, 23-1014, and 23-3172. It's International Union of Operating Engineers, local versus NLRB, as well as other parties. We're going to begin with oral argument from the appellant, and Mr. Davidson will begin with you.
May it please the court, my name is Steve Davidson and I represent Local 150 in this matter. There are two issues that Local 150 is appealing today. Issue number one, whether Riverstone violated 8A3 of the Act when it disciplined and discharged replacement worker Matt Kelly, and issue number two, whether the 8A5 violation of the Act applies to replacement workers. With regard to the first issue, the administrative law judge found in Local 150's favor. The board reversed with one of the three members of the panel dissenting. Recognizing that the ALJ found in favor of Local 150 is important because the board's evidence in cases in which it does not accept the ALJ's finding must be stronger than in cases where the findings are accepted. Matt Kelly's trouble started on May 6, 2019, when he revealed himself as a union supporter. He approached his supervisor, Scott Skirston, with a t-shirt that read Local 150 and asked Scott what he thought of his t-shirt. As the dissent pointed out, Scott Skirston responded, quote, "Oh geez, you've got to be kidding me. Are you taking Joe Elena's place?" End quote. Elena was another hand-picked replacement worker hired about the same time Kelly was, and Elena came out and revealed himself as a union supporter within 2 months of being hired.
Mr. Davidson, we've got a circumstance, as you pointed out, where the ALJ rules one way, the board another with the dissent. How do you suggest that we deal with our standard of review, given the law with regard to the board?
Well, the court does give a deferential standard to the board. However, because there's a dissent in an ALJ finding opposed to what the majority found, the weight that they give the ALJ, I think they have to give a closer look at the evidence and analyze the evidence from the ALJ's point of view, because the ALJ was the person listening to all the evidence, making all those initial determinations. And I think in this case, what occurred...
What's your best case for that argument? Because the standard of review is very deferential to the board's decision. So what case can you cite to that points to the visual when there's a dissent or when the board overrules the ALJ? Our look at the evidence should be different than if let's say the board just affirmed the ALJ across the board.
In Holochrome v. NLRB, Second Circuit case, where I cited that the evidence in cases in which the board does not accept the ALJ's finding must be stronger. I think that sets the standard, because when the ALJ hears the case and understands it, the board should be reviewing with the eyes of the ALJ. And in this case, what occurred was the majority, the two members, completely overlooked a number of factors presented to the ALJ and which the dissent understood. For example, the majority does not even address the issue of the timing of all the discipline, does not address the issue that Matt Kelly was issued 5 disciplinary notices within 4 days after revealing himself as a union supporter. Those are the facts that the ALJ understood, that the dissent understood, but the majority just completely glossed over and did not even consider those factors.
Is your argument toward the end of a pretext?
Yes.
And is pretext a factual question or a legal question?
I think it's both. The facts in this case, the evidence shows that the timing, the suspicious timing, the volume of the discipline issued, the fact that Scott Skirston, the supervisor, did not discipline anybody for the same tardiness type issues prior to Matt Kelly revealing himself, that the Skirston actually was untruthful under oath before the ALJ. All of those are factors that play into the pretext issue. And under right line, the pretext shows that absent, in this case, absent the union activity, there's no way Riverstone would have terminated Matt Kelly.
What do we make of the fact that Mr. Kelly conceded or admitted to all of the various violations that he was accused of from the employer?
Judge Lee, thank you for asking that question. He did admit, for example, the boss came up to him and says, "Hey, you were late." "Okay, boss, I was late." That admission is in no way, shape, or form him being disciplined for being late. There's no way you can get around whether you're punching at 6 o'clock or 6:15 or whatever. You're late.
So
you're late.
I guess I'm trying to. So is your argument that not that he wasn't late, but that the employer didn't follow the progressive discipline procedures?
Correct. The Riverstone has a specific procedure where they're supposed to give notice, and there's a form that the Riverstone fills out that tells you what happened, when it happened, prior incidents, and all of those factors. They're supposed to, according to their own policy, sit down with the employee, explain that to him, walk that person through that, and then explain what happened and the consequences if it continues. Riverstone did not do that. In fact, they hid the first two tardiness issues until I think it was August 7th, and that was 3 months after the actual tardiness.
But they told him that he was tardy at the time, right? When you say they hid,
At the time, there was a discussion that said, "Hey, you were late," but that doesn't amount to discipline. Prior to May 6th, he was late and not disciplined. Prior to May 6th, other employees were late and not disciplined. Just because you're late, that doesn't mean you're automatically disciplined for being late.
weren't there some employees that were disciplined for being late after Mr. Kelly was terminated?
Yes, there was one individual who was disciplined twice after, but I think that proves our point. Prior to May 6th, you could be late, you could show up at any time, you could punch in early, you can punch in late, and Riverstone understood that and allowed that. As soon as Matt Kelly explained, "Hey, I'm a union supporter," then they cracked down on those rules, and they were hyper vigilant on all those rules.
Is there any evidence in the record that the other person that was disciplined for being late after Mr. Kelly's termination was disciplined because of union activities or union involvement?
There's no evidence that that individual was involved or showed his support, visibly showed his support for the union. So, no.
Would you like to reserve the remainder of your time for rebuttal?
Yes, thank you, Your Honor.
Very good. Thank you, Mr. Davidson. We'll now move to Mr. Eggers.
May it please the court, Arthur Eggers on behalf of Troy, Grove, and Vermilion Quarries Divisions of Riverstone Group, Inc. Your Honor, in this review, we raised several points. One is that the board's finding that permanent replacement workers during a strike have Weingarten rights has no reasonable basis in the law, and I would submit to the court that the standard to be applied is that to the extent an NLRB ruling has no reasonable basis in the law, it should be set aside or reversed. The reason for that is because in the IBM Corporation, the NLRB considered the issue as to whether or not unrepresented employees have Weingarten rights. The board said no, they don't. A reason given by the board for that is that there's no common interest safeguard. And in this case, dealing with permanent replacement workers, there's even a stronger argument that there's no common interest safeguard. The reason for that is because striking employees want their jobs back. Permanent replacement workers want to keep their jobs. The board has correctly found that creates an inherent conflict. There cannot be a common interest safeguard when there is an inherent conflict. The board has also found that with regard to Weingarten rights, shifting the imbalance of power from the employer to the employee, that can't be done in a non-union setting because the union does not have the authority to make things happen. That is even more true with regard to permanent replacement workers, because even in this case, the board has found that with regard to wages, hours, terms, conditions of employment, the union can't do anything with regard to permanent replacement workers. And there's a situation we're going to talk about in a few minutes that deals with an alleged unilateral change. The board says, no matter how that goes, there's not a unilateral change as to permanent replacement workers, because the employer has the right to establish, change wages, hours, terms, and conditions of employment as to those employees. So in consistency with existing law, there should be a finding that there are no Weingarten rights with regard to permanent replacement employees. The second point that I'd like to address is the issue as to Riverstone allegedly violating the act by informing an employee, Joe Elena, that he was not being returned to work because, quote, there are no job openings at this time. That's what he was told. It's absolutely clear and unequivocal. Why isn't he coming back to work? There are no job openings. That's what he was told. Then also in the same letter, he was told, if you want to sign, if you wish to sign a preferential hiring list, you can do that. There's no necessity at all for putting his name on a preferential hiring list, because he was the only employee that hadn't been brought back, because at the time he wanted to come back, there wasn't an opening. A list is not a name. A list is not one item. That's not a list. A list is something that establishes order, that establishes sequence. One item won't do that.
So I guess I'm confused. Why tell him, why give him that information or give him that option?
Because the company had established a list in case it needed it, in case there was more than one employee that wanted to come back and there weren't openings. And as long as they had the list, they thought they should give him the choice if he wanted to sign it. Whether he signed it or not didn't matter at all. Now, if the company had not brought him back when there was an opening, we'd be having a different discussion, and it probably wouldn't go well for the employer. But that's not what happened here. With regard to the third item, which is the punch-in policy, Riverstone had an unwritten policy or a practice of allowing employees to punch in before their scheduled starting time. They could do that. Then what happened was that there was an unprecedented employee abuse of this policy. And that is an employee by the name of Matt Lauer decided that he would punch in 30 minutes early, 3 days in a row, earlier than any employee had punched in, and his reason for doing that was to test whether or not he would get paid. He was gaming the system. And because of that unprecedented abuse, then the employer clarified its policy and said 5 minutes early. And the reason why it did that is because the way it was doing it before led to the unprecedented employee abuse, just like in Allied Mechanical Company, which we cite in our brief. And it was that unprecedented employee abuse that led to the change, led to the clarification of the policy. And an employer responding to unprecedented employee abuse by clarifying a policy is not a violation of the act. The next item has to do with Jim Misericola. He's a persuader. A persuader is somebody, as the court I'm sure is aware, is hired by an employer to communicate with employees. The employer has the absolute right to communicate with employees as to its thoughts with regard to the union under 8C of the Act, so long as there aren't threats or promises. There's no allegation in this case at all that there was a threat or a promise. There's no question with regard to what was done by Mr. Misericola. It's not proven, it's not even alleged. So what the employer was doing is exercising its absolute right under 8C of the Act to communicate with employees. What does the administrative law judge find? What the administrative law judge finds is that the employer, just by employing Mr. Misericola, showed union animus. Just by employing him, that alone. And that is directly contrary to 8C of the Act, because the employer had the absolute right to communicate and to employ a persuader to do that. Why does that matter? Because in this case, the administrative law judge also makes a finding that Mr. Misericola stole a picket sign. At hearing The question is asked of Mr. Misericola, did you remove a picket sign from Troy Grove Quarry or Vermilion Quarry on public property? Answer, no.
Well, the testimony is actually much broader than that. It
It
wasn't
is.
a single word, right?
Sorry, Ryan.
Yeah.
It goes into
There's some
other things.
equivocation, there's some denial, there's some back and forth.
Correct, Your Honor, I agree. But as to the specific point, did you take the sign? That's the question, that's the answer. And what the administrative law judge finds is that that's a general and hedging denial. Denial meaning denial of the specific allegation put to him about stealing the sign. And it isn't. So the reason why we get to this point, and keep in mind what was said by this administrative law judge about the employment of him in and of itself being union animus, is that this judge addressed a credibility finding with the thought in her mind that he was necessarily, you can fill in the word, bad, evil, something. And because of his employment alone, it was union animus. Now, I recognize that this court certainly is very deferential to findings with regard to credibility. I'm aware of that. But I believe the premise of that is that the finding of credibility cannot be influenced by a belief that there's been a violation of the law by the employer and necessarily then something wrong about a persuader.
But wasn't there testimony that there were a couple of other employees that were across the street and the sign was there? This person pulls up in their truck or car. They can't see the sign because it's being blocked. The car leaves and the sign's gone. And so that's just why isn't that just a straightforward credibility determination considering the totality of the circumstances of the events of that day?
Because what this judge said, this administrative law judge said, is that there was a general and hedging denial. If the judge had based her finding only on what you said...
Okay, you mean so if the judge said, okay, well, he said he didn't, but I think he lied, that would be enough then?
If the judge had only focused on what you spoke of, Your Honor, and just said, I'm just going to think about what these people say they saw and what happened and they think happened, and I'm going to make a decision on that basis, we wouldn't be having this discussion now. The reason for this discussion now is because she didn't stop there. She went on to say that what Mr. Misericola gave was a general and hedging denial. That's an important part of her decision. And when she says that, she steps over a line. And the line she steps over is that she makes a determination that the person testifying is a bad guy, is an evil guy, is a reprehensible guy, so bad that just employing him is proof of union animus.
Would you like to reserve the remainder of your time, Mr. Eggers?
Yes, thank you, Your Honor.
Thank you. We'll now move to, you're okay, we'll reset it.
Okay, thank you, Your Honor.
We'll now move to oral argument from the appellee. We'll begin with Mr. Francisco Fitzmaurice.
May it please the court, my name is Brady Francisco Fitzmaurice for the National Labor Relations Board. The board is here today seeking enforcement of its decision and order finding that Riverstone violated sections 8A5 and 1 of the National Labor Relations Act. I'll turn first to the violation of section 8A5. Substantial evidence supports the board's finding that Riverstone unilaterally implemented, without providing notice and an opportunity to bargain, a new policy prohibiting employees from punching in more than 5 minutes before their scheduled start time. This is a straightforward analysis. There's no dispute that there was no punch-in policy before January 2019. There's no dispute that there was no notice or opportunity to bargain given. And as counsel for Riverstone stated, there's no dispute that there was a well-established practice of employees punching in as soon as the gate was unlocked and they were let into the facility when they arrived. These facts make out a clear violation of section 8A5. By posting the new policy in January 2019, Riverstone departed from the practice that existed without without bargaining with the union.
Do we know whether or not the individuals who punched in early were working in that time frame between 5:40 and 6 a.m.?
I don't believe the record reflects that information. What the employees testified to is once they got to the facility, generally the gate was locked, and if they were there early, they had to wait for the gate to be unlocked. Once the gate was unlocked, they proceeded in and went to the time clock and punched in. At that point, I'm not sure exactly what happened. There was some testimony about there being a huddle in the morning to discuss what work was to be done that day. Riverstone's counsel points to Allied Mechanical on this issue. First, I'd just like to point out that it's unfortunate this case was not cited in their opening brief. We would have addressed it in our responsive brief if it had been so. Nonetheless, I'm happy to address it today. In that case, there was policy in place, a written policy that the employer had stating you may earn overtime for hours worked over 40 hours per week. Then there was an intervening period where there was some time available to be worked on Sundays, during which double pay was available. And during that time, some employees gamed the system, and the employer departed from its policy and made payments double time on Sundays. And then clarified that you must work 40 hours per week in order to earn any overtime pay. So that clarification was entirely consistent with the existing written policy that had been in place at that employer. The difference is that here, there was no written policy in place. Whereas in Allied Mechanical, there was no change from policy because the clarification was entirely consistent. Here, there was clearly a change. Previously, employees were able to earn overtime for the time before the scheduled shift start, and afterward, they were not able to outside of those 5 minutes. Now, the board narrowed this 885 violation and clarified that it did not extend to replacement employees hired during the strike. This is a point on which the union disagrees. And first, I'd just like to raise to the court that the union is precluded from raising that claim at this stage of the proceedings. It never urged that objection before the board, and under Section 10E of the Act, the court is jurisdictionally barred from hearing it at this stage. The union disagrees with that contention. I'm happy to rest on our brief. We quoted direct quotes from their answering brief during the administrative proceedings that make clear during the administrative proceedings, Riverstone urged the board to narrow that violation. The union did not oppose narrowing that violation. What the union said was, this change applied to all employees, including those who are not replacements. Therefore, there is an 885 violation. That's the position that won the day. The board agreed and said, yes, there is an 885 violation, but not as applied to strike replacements. And the reason for that is there is no duty for an employer to bargain over replacement employees. That's been long-standing law at the board under Detroit newspapers, as well as in this court under capital hustings.
But that's with regard to the terms and conditions of employment, right?
Correct, Your Honor.
The union still represents replacement employees because they're part of the bargaining unit.
Absolutely right. Capital husting also says that. And so this brings us to a point of divergence.
And just so, if you can enlighten me, what are some other circumstances that might arise where the union would represent replacement workers, but that doesn't include bargaining with regard to terms and conditions? So, like, for example, is there discipline? Can replacement workers ask for union representation? What other contexts does that come up?
So there are two sections of the Act at play here. There's Section 885, which has to do with the duty to bargain, and I think that's what Your Honor's question is about. Under these circumstances, I can't think of any situation where an employer would be required to bargain over replacement employees' terms and conditions. I think that's clearly set aside by Detroit newspapers, and that's the issue presented here. Section 7 of the Act is another section that gives employees rights to engage in concerted activity for mutual aid or benefit, as well as union activity. And it's from that section of the Act that the Supreme Court drew the Weingarten right to representation during an investigative interview that might lead to discipline. So that leads me to the violation that the board found that Riverstone denied Matthew Kelly's Weingarten right and thereby violated Section 881. So again, that is not an 885 violation, that is an 881 violation. because it interfered or coerced with Mr. Kelly's right to have a union representative present during the investigative hearing.
Is there any possibility of a novation or some other substitute agreement? There is these facts that this other person is asked, what about this other fellow? Could this person come in? And Kelly says yes. That person is not the union rep. That union rep is still 20 minutes away at the other quarry. How does that affect the Weingarten analysis?
I thank you for your question, Your Honor. First, I would note that this question pertains to the application of the Weingarten right. And Riverstone raises no claim that Weingarten was misapplied here. Riverstone's only claim is that there is no Weingarten right as to replacement employees. So I think that the court can dispose with the issue there. But to address Your Honor's question more directly, Weingarten requires that the employee be given their chosen union representative. And in this case, the union steward was identified by name in a letter from the union to the employer months before this interview took place. So the employer was well aware of who the steward was that should be present for such interviews. Moreover, that union steward was located at the other quarry, as Your Honor mentions, about 20 minutes away. Well, who else was located at that quarry? The manager who traveled from that quarry to the investigative interview for that day. So what Riverstone did was it invited the manager from the quarry to travel to the interview, but did not invite the union steward. What Weingarten requires in that circumstance is that an employer provide a reasonable time for the steward, for the chosen representative to arrive. And if it does not wish to do so, it can present the employee with the option not to proceed with the interview, if they so wish. But that option was never presented here. I'll move on to the Section 8A1 violation as to the preferential hiring list. So here, Riverstone interfered with Mr. Elena's unrelinquished right to be recalled to work upon his unconditional offer to return. Under Laidlaw, which has been board law for decades, when a striking employee makes an unconditional right to return, they have a right to return to their former job. There is a distinction between unfair labor practice strikers and economic strikers, but I don't think that this case presents that issue. So what we have here is Mr. Elena made an unconditional offer. In response, Riverstone sent this letter to him attaching a preferential hiring list. And I invite the court to take a look at General Counsel Exhibit 6B for the language on that list. That list said that in order to make an unconditional offer, you should sign this list. The clear implication is that Mr. Elena has not made an effective offer to return to work unless and until he signs that list. But that's not what the law is. The law says all he has to do is make an unconditional offer to return, which he had done. Under Peerless Pump, the 2005 board case, requiring unnecessary paperwork for an employee to invoke that right violates Section 8A1. Riverstone asserts that there was no job available, so the record does not show Mr. Elena was passed over or refused a job to which he was entitled. That's fine. There's no contention that Mr. Elena was passed over. Section 8A3 deals in discrimination under the Act. If he had been passed over and denied a job, perhaps we would be dealing with a Section 8A3 violation, but that's not what we have here. All we have is a violation of Section 8A1, which states that it's unlawful for an employer to interfere with employees in the exercise of their rights under the Act. And unnecessary paperwork in invoking a striker's unrelinquished right to return to work does exactly that.
Could we hear from you, counsel, on the whether or not Mr. Kelly would have been discharged anyway? The whole idea, there's argument offered that ALJ is going one way, board is split on that. Your thoughts?
Yes, Your Honor. At the end of the day, the standard to be applied by this court is the substantial evidence standard. Does substantial evidence support the board's finding that Riverstone carried its burden to show it would have disciplined and discharged Mr. Kelly even absent his union activity? And the record here is clear on Mr. Kelly's misconduct and his infractions. He does not dispute that he was late multiple times, that he committed other infractions, using a cell phone while driving a truck, going into a shop while he should have been working in a pit, things of that nature. And so the only question is, assuming that there was a motivating factor of his union activity. That was a motivating factor in his discipline and discharge. Let's assume that's the case. That's what the board did. Even so, would Riverstone have taken the same action? And the record says that yes, they would have. He committed these infractions. The progressive discipline was issued in accordance with policy. He was disciplined 4 times for attendance within a 12-month period. Got a first warning, a second warning, a final warning, and then discharge. That's what the policy requires, and that's what Riverstone did.
What do you make of the argument that the company didn't follow their formal disciplinary procedures in issuing a disciplinary notice, allowing him to have a hearing to contest it, et cetera, et cetera?
So yes, the record does show that Riverstone did not actually hand the discipline forms to Mr. Kelly contemporaneously in every instance. But on the other hand, the record shows that they did counsel him along the way. Whenever he had a violation, there maybe were 1 or 2 instances where this did not happen, but overall they let him know that he had broken the rules and violated company policy. Also, these forms were provided to the union. The record shows that the union representative Russo did have these forms. At the end of the day, the question is, would Riverstone have taken the same action? Mr. Kelly committed these infractions, admitted to them, and the policy required that he be given this progressive discipline. There are cases that the union cites where the progressive disciplinary system has been manipulated, and this leads to a finding of pretext. But they're distinguishable from the facts here. In those cases, those are Mid-Wilshire and LeMadry. In LeMadry, the company skipped steps in the progressive disciplinary system. That didn't happen here. In Mid-Wilshire, there was double counting, meaning an employee was warned, refused to sign the warning because he deemed it illegitimate. He was given a second warning for refusing to sign the first. He refused to sign the second. He was given a third warning for refusing to sign the second. Okay, this is a manipulation of the progressive disciplinary system. That's not what Riverstone did here.
Same question I posed to Mr. Davidson. Is pretext a legal question, a factual question? Your thoughts on that?
I'm happy with the answer that it's both. I mean, it's a legal question, but it requires application of lots of the facts. As to the facts that that Union Counsel pointed out, I think he mentioned that some of the disciplinary forms had not been issued contemporaneously, and that the procedure had not been followed. The board recognized all those facts. The board did not disregard any facts. In fact, it adopted the ALJ's factual findings. And the only part of the analysis that the board disavowed was the legal analysis under Section 8A3 for Kelly's discipline and discharge.
So for questions that involve mixed questions of law and fact, sometimes one of the things we look at is it predominantly one or the other, right? Is the finding of a determination of pretext predominantly a factual question with some application of law, is it predominantly a legal question with some findings of fact? Do you have a position as to on which side of the spectrum or which has that line pretext comes in?
I would say closer to the side of the line of a question of fact. And the reason for that is the ultimate question here. Does substantial evidence support that Riverstone would have disciplined or discharged regardless of union activity? This is a question of fact. What did they do, and what would they have done if you excise the union activity? And I think that the record strongly shows that they would have discharged him. The board was faced with a scenario here where it had to make a tough call. Either this discipline and discharge was unlawful, or it was not. The board found it was not unlawful. If the board had come to the other conclusion, I would be standing here asking questions that are at least as difficult as the ones I'm answering today. One last issue to address. This has to do with Mr. Misercola's removal of the union picket sign. This does come down to a credibility determination. And the court is well aware exceptional circumstances are required to overturn a credibility determination. There were 2 witnesses who clearly testified to Mr. Misercola's conduct that day. They were 50 to 80 yards away. They were the employees who placed the sign there. As soon as Mr. Misercola left, one of them went over and saw that the sign was gone, saw the tracks in the mud from Mr. Misercola's truck, and The judge and the board affirmed that those employees testified credibly. Mr. Misercola did not. It's true that he gave a one-word response in responding to the questions of whether he had ever removed a sign. His direct examination was, I think, 2 or 3 questions long. But I draw the court's attention to his subsequent testimony on cross. That's at transcript 313 to 317. Now, he was first evasive as to the simple question of how long he had worked for Riverstone and what services he provided to them. He was later hedging on the very clear question of whether he had ever driven off the road when leaving Riverstone's facility. The judge was, well within her well-reasoned analysis to find that his denial as to those points was hedging and discredited him as a result. As for her finding that Riverstone harbored anti-union animus as a result of employing Mr. Misercola, this is not relevant to the 8A1 violation that we have before the court today. That came up in the judge's 8A3 analysis as to whether Mr. Kelly was disciplined and discharged for union activity. Animus has no bearing on an 8A1 violation. So I see no reason why the court should be concerned with it. Riverstone was well within its rights to employ Mr. Misercola as a persuader. It has a right to do so under Section 8C. The board did not say otherwise. I see that I have 2 minutes remaining. I think that I've covered all the points that I intended to. Unless the court has additional questions, I thank you for your time, and the board requests full enforcement.
Thank you. Counsel, we'll now move Ms. Friedman to you.
May it please the court, Andrea Friedman with the Department of Justice, and I'm here on behalf of the National Labor Relations Board attorneys who have appeared in this case in their personal capacities, and I'm here solely to address the motion for sanctions that was filed by the union. And I don't plan to take very much time. I have 2 really brief points on this issue. The first is that the issue raised in the motion for sanctions is really just a merits dispute. It's obvious from the briefing, especially the union's reply, that this is a garden variety merits dispute, and this issue is one that the court is here to decide. I think counsel for the board very well explained the issue with regard to the punch-in policy and the 10E argument, and I won't rehash that, as he is, of course, the expert on that. The second point I want to make is that personal sanctions, personal monetary sanctions against the board attorneys in this case would be an extreme measure and is clearly unwarranted. The case law is really clear. Egregious conduct is what we're looking at for sanctions, and in particular personal monetary sanctions. The examples that we can see in precedent, they usually involve repeated prior warnings from the court or an utter absence of any legal authority whatsoever, and that's just not the case here. Prior courts that have issued sanctions have also denied requests for sanctions, have pointed out that even a litigation long shot is not the same thing as a frivolous or bad faith argument. And this isn't even a long shot here. The board hasn't made a long shot argument here, as the board counsel has explained in its briefing and in its argument here today. The board has a meritorious argument here. So there's just been no abuse of judicial process here whatsoever, and sanctions, the sanctions motion should be denied.
Thank you very much, Ms. Friedman. Thank you. We're now going to move Mr. Davidson back to you for a rebuttal argument.
Thank you, Your Honors. Addressing what Ms. Friedman just mentioned, we agree that this is a merits dispute, but they filed a motion to arguing that we waived one of our arguments, and in no way, shape, or form did we waive any of our arguments. And in fact, we won at the ALJ level, and then when Riverstone filed its exceptions, we answered those exceptions in our answering brief, and at pages 45 through 47, we spell out our argument that this is an 8A5 violation. It applies to replacements as well as striking employees, crossover employees, it applies to everyone. So in no way, shape, or form did we waive that argument. They also mentioned something about us failing to file a motion to reconsider. Well, that's disfavored by this court and not required under the Seventh Circuit law. A couple of other points I'd like to make is as far as employees abusing the punch in early policy, one of the employees had been doing it for 18 years. Not 8 years, not 8 months, 18 years. And never been told, never been disciplined, never changed. So as far as anybody abusing that situation, it wasn't the case. You know, coincidentally, maybe that's more evidence of a union animus because the individual, Brad Lauer, who started doing that was a union supporter that the employer knew about. And as soon as he started punching in early, that's when they changed the rule.
I take it when someone punches in, it records the time, so you're just not looking at the aggregate time they're at work. It actually plainly states what time the person actually put their card into the punch machine.
That is correct, Your Honor. So when they show up early, they punch in, and then when they leave at the end of the day, they punch out, and it does timestamp their time card. And this industry lends itself to individuals punching in early because there are some tasks that one individual does, and then the other people come in. So somebody will come in 15, 20 minutes early, get everything prepped, so the second person comes in, so that team starts working. So there is some economy and some business justification for that. As far as the conflict of interest, absolutely none existing here. There were decertification elections going on at this time, and the union won the decertification election. We won with more replacement workers voted for the union than against the union. And actually, when we ratified the contract, there were 11 replacements voting and 3 strikers, and the vote for ratification was unanimous. I see my time has expired. Thank you. Thank you.
Thank you very much, Mr. Davidson. Mr. Eggers, we're now going to move to you for rebuttal argument.
May it please the court, with regard to the first point I'd like to mention, which is Allied Mechanical. In Allied Mechanical, 2 things going on. One is that Allied Mechanical had a written policy with regard to overtime over 40. Allied also had a practice of paying employees double on Sunday if the customer was reimbursing for that. So what changed in Allied Mechanical, just like in our case, is that there was an unwritten policy or practice that was being abused. The overtime over 40 wasn't. What was being abused is employees were getting double time on Sunday without having worked during the week, which Allied felt should happen. So our case is the same as Allied. It was an oral policy or a practice. It was being abused, and it was clarified, and that's what happened. With regard to the second point, which is the point about the Elena and the issue about the preferential hiring list. What Elena, nothing has changed. What is clearly said in the letter is he's not being brought back to work because there are no job openings. That's what he knew. That's what he was told. He was also told that if he wished, he could sign the preferential hiring list. There's absolutely nothing here that imposes an obligation on him to do anything more to come back to work. He has to wait until there's a job opening. He did. He returned to work.
Mr. Edwards, the form, though, that they gave him, at the top of the document, it has the sentence, right? If there was a group offer to return to work, employees will be placed on this list based upon their date of hire. Doesn't that give the reader some indication that you have to be on the list at some point in time in order to kind of, so that the employer can kind of go down the list and figure out whose turn it is and who's up?
Yeah, correct, Your Honor. With regard to the language in the preferential hiring list, when there's a group offer to return to work, there wasn't. There's nothing in the evidence that there was a group offer to return to work. There wasn't. The only person that wasn't brought back was Elena. And with regard to the issue of signing that at all, in the information that he's given, it says you may sign it if you wish. There's nothing that says you have to. There's nothing that says it's a qualification of returning to work at all. With regard to the argument with regard to misericola and proof of union animus, appreciate the comment made by the attorney for the NLRB acknowledging that under 8C, my client had the absolute right to hire a persuader. There's no doubt about that. It proved nothing other than the fact that my client was exercising a right given to it under the National Labor Relations Act. With regard to the argument that the administrative law judge made the determination of union animus and therefore necessarily what a bad, evil person Jim Misericola is when addressing a different aspect of this case means, respectfully, means nothing. The human brain doesn't function that way. None of us have a brain that will allow us to put in one part of our brain that someone is evil, vicious, bad, rotten, probably other words I'm not thinking of, and then somehow seal that off and not let that affect our thinking as to that person when we're making a credibility determination. So I'd respectfully submit that the court should modify or set aside every part of this NLRB order that makes any finding against my client Riverstone. Thank you.
Thank you, Mr. Eggers. Thank you, Mr. Davidson. Thank you, Mr. Francisco Fitzmaurice. And thank you, Ms. Friedman, for your oral arguments. The case will be taken under advisement. We'll now move to Appeal 23-2364 and 16-3508, Robert Fletcher et al. Versus Peter Doig. We'll begin with oral argument. Mr. Is it Cedillo?
Cedillo.
Cedillo for you. Thank you.
Thank you, and good morning.
Good morning.
I represent only Mr. Zieske in his appeal of the sanctions order. And I want to begin by saying that a case with weaknesses is not a frivolous case.
Mr. Cedillo, this case had more than weaknesses. You know, here's what I'm most interested in this case. This is an interesting mess, in my view, that we've got here. We've got a judge who denied summary judgment based on, in my view at least, the exact same facts that the judge relied upon to impose sanctions going back to 2 years before the denial of summary judgment. But let me ask you, what do we do with this? You know, you've got, I understand your argument with respect to send it back, you know, reverse the sanctions order. And of course, you want no sanctions here. But this case was, beyond extraordinarily weak. And what I'm interested in is, if the district judge, if we remand this case to the district judge, what is the district judge to do with it? Okay, meaning what is your theory, or what is plaintiff's theory at trial by which plaintiff could have possibly won this case?
It was, and again, there was gaps in the record, but what it came down to was a credibility determination. And if you read the trial judge's oral findings in the transcript, the judge made no less than 34 different credibility determinations.
This is at the summary judgment transcript?
No, this is after trial.
At the
This
trial.
is the transcript of the oral rulings in August 2016, I believe it was, after the trial. Those included the artist Doig, his mother, Doig's sister Bovard, the experts, and then it did not find Fletcher intentionally untruthful, and then it found his memory lapsed after 40 years understated.
But what I thought what the judge found is just a total lack of proof by the plaintiff. The plaintiff continued to pursue a case that the plaintiff could absolutely lose, and unequivocally was going to lose. And the problem is somebody is on the hook for these fees that the defendant was, I guess summary judgment should have been granted for the defendant. Period. That would have resolved this. but it wasn't. And so who's responsible for the fees after summary judgment was denied? Because your client continued to pursue, in my view at least, a less than frivolous lawsuit. I don't think in my, 25 years of practicing law, I don't think I've ever seen anything like this.
It's not a case I've seen before. I will agree with you there. But there was evidence that the judge ruled was sufficient to go to trial. And there were gaps in the record. And I will add that defendants were partially responsible for the denial of summary judgment. Their own exhibits contained inconsistencies in the dates of their emails between Doig, the artist, and his domestic partner were inconsistent as to when Doig was working on this oil field in Alberta, which would have precluded his presence in Thunder Bay at the time. And then there were the letters from Doig's mother that the defense didn't produce until a week before trial, and which were ultimately excluded from evidence, in which the trial judge did say he would have granted summary judgment had he had those letters at the time. So,
Well, that might make it worse for you, by the way. I mean, you had the letters, or at least your client had the letters.
not until a week before trial.
Oh, I see.
And there was no chance to.
I think you said a week before summary judgment.
I'm sorry, a
Summary
week
judgment.
before trial. And there was no chance to hold those up to scrutiny, to depose any witnesses, to request further, and that's why they were excluded. And ultimately, those didn't factor into the judge's trial determination because they weren't in evidence.
Mr. Cedillo, would we, if the defendant hadn't filed for summary judgment and this case just had gone to trial and the judge found what he did at trial and imposed the sanctions, would we even be here?
I think we would still be here you're saying if the judge imposed sanctions.
No.
Well, I see that-
If summary judgment procedure never existed,
Okay,
right? And
but
this
the judge
case just-
still imposed
yes.
sanctions after trial.
Yes.
I think we would still be here because all the evidence that was contained, well, maybe we wouldn't be. All the evidence that was contained in the Rule 11 letter and then the subsequent affidavit of Bovard, which was sent, which was the key in the judge's May 7th trigger date for the sanctions award, was seen by the judge at summary judgment. And the judge looking at that said, oh, there's enough here to go to trial. Had that evidence gone to trial...
Well, that's not exactly.
and-
I mean, that's, to be fair, that's not exactly what he said, right? What he said was, I cannot assess the credibility of Mr. Fletcher, and I have to also draw whatever reasonable inferences there are in his favor. And so, given those things, I can't grant summary judgment. And frankly, if he had granted summary judgment and the case was appealed, I'm not sure what we would do with that.
Well, that wasn't the only determination the judge made. There was an affidavit, and yes, he did have to assess credibility, but there were documentary evidence included as well. And the judge ruled there were evidentiary gaps that needed a fact finder to resolve. And ultimately, those resolved against the plaintiffs in this case.
What about, Mr. Cedillo, the idea that viewing the evidence in light most favorable to the non-movement at summary judgment and these being factual circumstances means that the denial of summary judgment doesn't necessarily preclude the assessment of sanctions?
Well, let's go back to the summary judgment standard for that. It's appropriate when no reasonable trier of fact could find for the non-movement. Now, what is a frivolous case? When there's no reasonable basis in fact or law. So we have that reasonableness standard. We have the judge on one hand saying a reasonable finder of fact could find for the plaintiff based on the evidence presented, yet at the same time during the chronology, there was no reasonable basis for bringing suit. That's an inconsistency that I don't think it doesn't, that warrants sanctions or that allows the judge sanctions awards to fail, at least at that point in 2016.
It looks like other circuits do allow for a finding of sanctions post denial of summary judgment. You rely on this LeBeau case.
Correct.
Didn't LeBeau involve a matter of law, though, rather than a matter of fact?
Well, and I think LeBeau, I think LeBeau It does involve the matter of law, but I don't think that should make a difference here. It's whether there's a reasonable basis to proceed to trial. If that's an issue of law, that certainly will be precluded or not. Issues of facts are less cut and dry, I will concede that here, but still there's a line where there's a reasonable basis or not. And I think if we read LeBeau in the context of what the Sixth and Second Circuits have done in the LeMaster and the Callaway case, particularly Callaway, because that involved an issue of fact. There was a falsified affidavit there. We have egregious conduct. In other words, there's something more than just the facts on summary judgment didn't bear out at trial. And I just want to highlight some of what these evidentiary gaps were that allowed the case to proceed to trial. There was sparsely documented whereabouts of Doig. There were no official records from the prison or the university. There's no signature on the university card. As Judge Kirsch alluded to, this is kind of a perfect storm of gaps in the record that required a finder of fact here.
But wait a minute. I mean, but the Royal Mounted Police, they put in evidence in the summary judgment record that no person with Doig's name, birth date, and fingerprints had a criminal record.
I believe that is correct.
How could the plaintiff possibly overcome that evidence to say that I actually met him in the penitentiary when the police are saying this man has no criminal record? I mean, and it gets back to the summary judgment question. My concern is that, yes, there are credibility determinations, but there has to be a genuine dispute of material fact. And when all the evidence is on one side of the table versus somebody's foggy recollection, to me, that's just not a genuine dispute of material fact.
That wasn't the only piece of evidence. I mean, it was in the record, I will agree to that, but there were other gaps. For example, the prison records. And there were, I believe, issues regarding the record keeping at that time that the police had. So again, and then there was no...
What evidence did Mr. Fletcher have that the painter, Doig, had ever been in prison?
He didn't have any positive evidence that he had been in prison. All he had was gaps in the record. And under the summary judgment standard, I think the judge correctly applied that and said this case has to go to trial based on that. We have to judge Doig's testimony versus Fletcher's.
Doig's testimony plus all the other evidence.
Plus the documentary evidence, which had gaps in it.
Doig versus Mr. Fletcher's speculation.
Well, his foggy recollection was the words used by the trial judge. And to resolve those gaps in the record, in the documentary record, which did exist. I do have the remainder of my time reserved. If there are no further questions, I will conclude there.
Thank you, Mr. Cedillo. We'll now move to Mr. Schaafboek.
Good morning, Your Honors. Christopher Schaafboek on behalf of the appellee, Peter Doig. May it please the court. The district court properly exercised its discretion, so its order should be affirmed. Mr. Zeisky does not challenge any of the district court's factual findings as clearly erroneous. So the narrow question on appeal is whether LeBeau created the novel rule that he urges.
Mr. Schaafboek, should summary judgment have been granted for your client in this case?
It's a close call, Your Honor.
How is it close?
I think for the reasons the district court articulated, there were three main pieces of evidence. One was the letter that appellant's counsel mentioned, where the defendant could not indisputably prove that the painter Peter Doig was not in Toronto during the time period. But then,
in what world do we live in where the defendant has to have irrefutable proof of his or her whereabouts at a particular time?
it was buttressed, Your Honor, by two more important pieces of evidence. And I think Judge Lee was getting to this point. It was Fletcher's credibility, which had to be decided in his favor at that point. And then also the plaintiff's expert witness, who the court said, in theory, could be able to substantiate that this other person, Doig, had made the painting. At trial, the court found that although the plaintiff's expert's theory was theoretically sound, it in fact didn't establish at all that the painting was made by Peter Doig. So that's one flip that happened at trial. And then you have Robert Fletcher's statement that I met Peter Doig, I bought the painting from him, that's the person I remember seeing. And given the mountain of evidence on the defense side, it is still a close question, but I think the court was not.
We deal with these cases all the time in prison contexts where an inmate says one thing and all the evidence is on the other side. And we find, or district courts routinely find every day, that does not create a genuine dispute of material fact.
Even if the court was wrong to deny summary judgment, that still doesn't absolve plaintiffs and their counsels.
And that's my question.
I think you're exactly right then. That doesn't change the analysis. The fees are still warranted. It's a lawyer's responsibility, not the court's, to objectively assess the strength of their client's claims and then to desist when it becomes apparent that those claims no longer have a reasonable possibility of prevailing.
I think, in my view, the case would be a lot easier if the district judge, in ruling in your client's favor, had said simply, I do not believe Mr. Fletcher, right? I think he lied. Because we have all this other evidence, and now that I've seen it all, I just, don't think, I think he's misrepresenting and that he's lying. But he didn't really say that, right? He said that at least he didn't say that expressly. He said that Mr. Fletcher's memory was, dulled to the passage of time. He doesn't think that Mr. Fletcher was intentionally misleading the court or anyone else. That makes it a bit more difficult for your position, doesn't it?
I don't think so. I think that it illuminates how egregious plaintiff's counsel conduct was, because he was sitting in a position to objectively assess that. He would have known that there were these gaps, that his client trying to remember something 40 years ago couldn't overcome the evidence that had been produced at that point, that was going to come in, that they expected to be admitted. The district judge wasn't in the same position. The district judge can't take that same lens. I'll also highlight for the court some of the things that came out at trial. For example, before trial on summary judgment, the defendants had submitted a declaration of Ernie Adams, who was the painter's, Mr. Doig's, art teacher in Thunder Bay Correctional Center. The declaration said, I reviewed the image of Mr. Doig. That was my student. I taught him art. He made the painting. Mm-hmm. In opposing summary judgment, plaintiff's counsel said that Mr. Adams had recanted, and he actually wasn't sure. He was less sure of the statements he made in his declaration. At trial, Mr. Adams testified that he had never recanted, and that in fact Mr. Zeisky had called him and threatened him with perjury in the U.S. Marshals if he wouldn't recant. But at trial, he stood by his declaration and said, yeah, that was my student at Thunder Bay Correctional Center, and that's the painting he made. At trial also, Fletcher said, quote, there's no factual basis, end quote, to dispute the Bovard declaration. So his testimony weakened over the course of the case too. I think one of the key points in this case is the September 2013 status hearing. That was 1 month after defendants produced the Bovard declaration. At that hearing, the district court told Mr. Zeisky he should strongly consider putting the brakes on this case, and he warned plaintiffs that the standards of review on summary judgment and a trial are different. In response, Mr. Zeisky said he was, quote, very comfortable with going ahead with the facts that we know. At that hearing, he also told the court, quote, I really don't want to disclose at this point everything that we found. I'll say it again, it's the lawyer's responsibility to objectively assess the strength of their client's claims. And to flip that standard, or to reverse at this point, I think would do damage to the summary judgment standard and risk flipping it in a damaging way going forward. I'll move to Shales next. Overruling Shales would, first of all, I think would not change the outcome of this appeal. Appellants concede on pages 7 and 10 of their reply brief that Shales is binding law of the circuit, and critically that the district court correctly applied Shales in awarding sanctions. The parties agree that the district court was correct in recognizing that Shales limited its ability to consider the sanctioned party's ability to pay. So even if the court were inclined to overturn Shales and adopt a new standard moving forward, that wouldn't change the fact that the district court did not abuse its discretion. It didn't misapply established law under Shales. I would add that the justifications given in Shales for not considering the sanctioned party's ability to pay are as relevant today as they were when Shales was decided. As for the reasonability of fees, I think it's clear from the record that the district court did not impermissibly presume that all fees were reasonable. Rather, and appellant concedes on page 11 of their brief that the district court did conduct an analysis and wrote down by 20% defense counsel's fees to account for its view of what the appropriate time was based on its overall sense of the case.
Can I ask you about Rule 11 and the amendment in 1993 and the advisory committee notes? Right, the advisory committee notes state that if a party has sufficient evidence with respect to a contention that would suffice to defeat a motion for summary judgment based thereon, it would have had sufficient evidentiary support for purposes of Rule 11. So that's what the advisory notes to Rule 11 says. What is your response to that?
I think the sanctions award should still be affirmed, regardless of the read of Rule 11 under Section 1927, which the court also relied on. And as this court knows, they can affirm on any basis fairly reflected in the record. But I think that advisory note doesn't change the fact that Rule 11 still is also an appropriate basis, given the sort of escalation of egregious conduct as the case pressed forward, as defendants kept producing more and more evidence, as the plaintiff's conviction in their belief in who they meant weakened. The case should have been withdrawn far earlier than trial.
Do you think the test or the rule that we should kind of adopt is different when a claimant survives or a movement survives summary judgment based upon his or her own statements versus external statements? So in other words, say that there's a case where, say that there's this case where it wasn't Mr. Fletcher, but it was some other person that was there, right? And there was affidavits based upon that person. And we still have this mountain of evidence on the other side. Do you think that that would present a different set of circumstances that would be meaningful in our deliberations here versus if it were Mr. Fletcher's own statements?
That if it was the plaintiff's own statements,
Right.
own credibility
Or-
determinations,
right.
that might put a thumb on the scale in favor of letting the case move
Right,
forward.
saying that, for example, say instead of Mr. Fletcher's own affidavit or his own statements, that there was a classmate of Mr. Fletcher's, right? And there's an affidavit by that classmate saying, yes, I saw him at that school, the artist at the school, and he used the one, right? And that's the only evidence there is. Would our consideration of this appeal be different in that context? Would that change your argument?
It may. That may make it more appropriate for the court to have granted summary judgment. I think that may be the case, but here we have the counterfacts. I mean, here we have the plaintiff saying I'm the one. So if anything, if there is a meaningful difference, I think this is the case that you affirm that the district court is right to err on the side of letting the case survive summary judgment, that the district court is right to err on deferring to the lawyer and their understanding of the strength of their case. I would also highlight for the court that the issue about LeBeau, I think, really controls this case, and it can be resolved on that fairly narrow ground. The appellant's argument is that LeBeau created this novel rule, that if you survive summary judgment for whatever reason, a plaintiff is categorically immune from the normal sanctions framework, that there has to be something more, there has to be an intent to defraud the court or actual malice. That's not what LeBeau says, and if the court agrees with our reading, that resolves the case, because when the district court correctly applied LeBeau, there was no abuse of discretion. As the district court correctly recognized, LeBeau held only that a sanctions award may not be based on a ruling that directly conflicts with an earlier ruling from the same court in the same case. And here there was no direct conflict. Judge Brennan, I think you asked this question earlier about LeBeau having this change question of law versus question of fact, and that's exactly right. In LeBeau, the district court in its pretrial orders and in denying summary judgment had said that the defendant's intent was a question of fact that had to go to a jury. And then later in awarding sanctions, it said that actually intent is a question of law, and thus the EEOC must have known as a matter of law they were going to lose. That is a totally different case than what we have here. Here there's nothing inconsistent with the two different standards and what the district court held on summary judgment, and again with all the evidence that came out at trial. Thank you.
Thank you, Mr. Schaffbach. Mr. Saddia, will come now back to you for rebuttal.
Thank you. I'd like to begin by pointing out that I disagree with the appellee's reading of LeBeau here. They would have LeBeau only limit the district court to small discrete issues decided on summary judgment, but that's not actually what LeBeau says. If we read the actual quotation, we can only say that when a trial judge rules here that there are facts under which a plaintiff can prevail, it is highly inconsistent for him to later find the suit frivolous because it is foreclosed as a matter of law. In other words, if there's a dispute of facts, the inconsistency applies to the suit, i.e. the claim, not these discrete issues that the appellees would have the rule extend to. And again, if it is inconsistent, something is required to overcome that inconsistency. And that's why I propose the reading of LeBeau to require not just a standard analysis, but there has to be something more that renders the case frivolous, i.e. with no reasonable basis after a district court has already found that a reasonable trier of fact could find in favor of the plaintiff, or the non-movement, I should say. Also, the appellees highlight the expert testimony, and that's not something that should be downplayed here. Another reason the district court denied summary judgment was the conflicting opinions of experts, which in an art case is to be expected given the subjective nature. And ultimately, in the oral findings after trial, the judge said, there was the analysis of Bartlow, who was acting as his own expert, was not unreasonable, was not objectionable in theory, and can make sense. And then in the sanctions award, the judge goes ahead and says Bartlow could not have reasonably believed in his expert conclusion. So we have the sanctions award contradicting the court's own oral findings after the trial. That and there's the inconsistency regarding Fletcher's testimony, which in the sanctions award all of a sudden became irreparably shaky, renders that award inconsistent with the judgment. And on that basis alone, it should be remanded to re-examine the appropriateness of the sanctions award here. It's inconsistent with the findings issued after trial. And then I also want to add as a final point that, and Judge Lee, your question touched on this when we were talking about a party's testimony forming the basis of sanctions. Here we're talking about sanctions on the attorney, who, yes, I agree it's the attorney's responsibility to vet the case, but he has to go with the evidence he has, including what the client presents him with. We have to look at the attorney's perspective differently from a party who's engages in sanctionable misconduct to survive summary judgment. And here, I don't think we can say that in May of 2014, Zieske should have known that he had no reasonable basis for the claim. And certainly when the judge denies summary judgment, what's an attorney to make of whether there's a reasonable basis to prevail at trial or not? We have the benefit of hindsight arguing here, and we have to look at this case from Mr. Zieske's perspective at the time he was litigating this case.
I'm not sure that's your strongest argument, in the sense that with the evidence just piling up against him, at some point he's got to have a conversation with his client and say, even if we get by summary judgment, our likelihood of succeeding or prevailing at trial is going to be very small. Let's try to settle this case, or let's get rid of this case. Doesn't he have to have that conversation?
I agree, you should have that conversation, but I think May 2014, that is not a conversation that was appropriate here. We can argue at a later point that may have become appropriate, but in May 2014, through the end of trial, that's what the trial judge found here. And my time is up, and I would ask that you reverse the sanctions award and remand. Thank you.
Thank you, Mr. Saddia. Thank you, Mr. Schaufbach. The case will be taken under advisement. We're going to take a brief recess. We're back on the record for the third case of the morning. This is Appeal 23-2446, Next Millennium Telecom versus American Signal. We're going to begin with Mr. Zahar, and he is appearing remotely.
Good morning, Your Honors. May it please the court. Your Honors, this is an appeal of a dismissal based on failure to prosecute in the Eastern District of Wisconsin in a case where all the trial exhibits were filed, motions eliminated were filed, jury instructions, jury verdict forms, and all the required documents necessary for trial were filed with the court. At the pretrial conference, instead of engaging in pretrial matters, the district court imposed for the very first time 3 new conditions on the plaintiff in this case as conditions to appear for trial. And the court ordered that the plaintiff file a plan within 90 days outlining how the plaintiff was going to accomplish the task.
Mr. Zahar, can I ask a question here? This is a breach contract case, right? I mean, you file a breach contract case. We bought a product and the product doesn't work, and the defendant. I mean, I just don't. This I don't get. The defendant says, well, we need to test the product to make sure it doesn't work, right? I mean, there'd be no defendant in the history of America that would say, we're just going to accept your word that the product doesn't work. And there's no effort or there's nothing that happens in a matter of years to provide the defendant with an opportunity to verify whether or not the product works or not. And you're going to go to trial?
So, Your Honor, we have never prevented the defendant from traveling to Saudi Arabia to examine the sirens.
Does that accurately reflect the record, though, Mr. Zahar? Your argument pitches it as if it's the district court's call and that the district court changed the dynamic of the case. But isn't the district court reacting to the years of litigation or non-litigation preceding?
So, preceding even the litigation, our client had made complaints with both the defendant, the Business Bureau, and even the United States Embassy with regards to the sirens. They've invited
Let's
the
go
defendant.
to the time frame then between the filing of the complaint and the final pretrial conference when the 90-day outline was described in that time frame. That's a set of procedure and factual circumstances the district court is reacting to when he's setting these 3 requirements, right?
Yes, and so during the litigation of the case, when the defendant had requested to examine the sirens, we even have emails where we have told the defendant, once you enter Saudi Arabia, we will accommodate you. We had no objections to them examining the sirens. It would have been beneficial for us for them to examine the sirens, and then they'll have that opportunity and we can proceed to trial. We had no issues with them traveling to Saudi Arabia to examine the sirens. The issue is them actually traveling to Saudi Arabia. I cannot control the defendant's travel.
Mr. Zahar, is my understanding correct that Robert Basil, that's his name, right? Who was with or formerly with American Signal, he traveled to Saudi Arabia during the installations, right?
That's correct.
And so I guess, and I'm going to ask Mr. Harvey the same question. So American Signal clearly knew how to send people over to Saudi Arabia, one would think. And so I'm just kind of confused looking at this record because it seems like, American Signal had sent people to Saudi Arabia before, so it's not like they were completely in the dark in how to go about doing it. And so I'm just trying to understand what the hang-up was here.
So so my client is a contractor. They're a separate entity. Where these sirens are located, they were on government property, or they're on government property. And so we had informed the defendant that come to Saudi Arabia, just make sure that, you get all the acceptable requirements to travel. Get that permission that, hey, I'm coming. Who is going to Saudi Arabia? Who's going to be examining the sirens? And so on and so forth. And, excuse me. And so that was where the hangup was, is they had applied for those, and whether they got it or not is on their end. That was not on our end. We have been ready for them to come to Saudi Arabia. We were going to accommodate them once they got there as the appellant. And that was it. But at
Mr.
the
Zahar,
end of,
though, they had to move to compel before the magistrate, Judge Duffin, to get the specific names and addresses of the individuals who granted Nextel its expert access. So it just seems like the narrative that we're receiving is one of cooperation. When one looks at the discovery and the docket sheet, it's one of real difficulty defending the case because of plaintiff's non-cooperation. I want to give you a chance to respond to that.
and so, Your Honor, briefly for that, we had given them the name, and they had also applied back in April. And back in April, they had applied, and we didn't know if they got a response or not. And then even after we gave them the name of the individual, we still don't know if they got a response or not as the appellant. So it never really changed. And then they had also said that they had visas back then. And then in an email to appellant's counsel in May of last year, they had told us that they needed letters of invitation from the government in order to obtain visas, which has never been heard of. If they had the visas prior, then they would have had to have those letters of invitation before, based on their own argument.
Mr. Zahra, in your brief, you say that, in your outline, you say that you were looking at the months of July and August 2023. By the time you submitted your plan, had you received permission from Saudi Arabia to conduct the inspections?
Our understanding is yes, we were going to be allowed to inspect the sirens.
You would,
that's why we get
you would, or the American Signal
the
would?
parties.
Okay.
The parties, and that's why we said between July and August, and we would have been able to work on a firm date. And I do want to reserve some time for rebuttal, Your Honors.
Very good. Thank you, Mr. Zahar. We'll now move to Mr. Harvey for argument on behalf of the appellee, American Signal Corporation.
Thank you, Your Honor. May it please the court. For decades, this court's case law has made it abundantly clear that trial courts have very broad discretion to control their own dockets. And so that's why in the Daniels case, for example, this court held it was entirely appropriate for the trial court to dismiss the plaintiff's case for failure to prosecute, and also to deter other litigants from engaging in similar tactics going forward. And in this case, the trial court did, as Daniels instructed, reviewed the whole procedural history of the case, not just this 90-day window, and held, in its discretion, that the appropriate remedy was to dismiss the plaintiff's claims. But it didn't do that lightly, not even close, because what the trial court first did, and its order makes clear, is it looked at the whole 3-year history of this case and the plaintiff's conduct in it, up to the pretrial in February 2023, and the judge at the pretrial said, this case has been pending for 3 years now. It's supposed to be going to trial in 2 weeks. In 35 years on the bench, I've never seen a case so ill-prepared for trial.
Mr. Harvey, can I ask you a question?
Yes.
So the defendant filed their answer to the second amended complaint on August 17, 2020.
That
Okay?
sounds correct.
Rule 16 then requires the district judge to issue a scheduling order as soon as practicable thereon. I don't see any order in the docket, no Rule 16 scheduling order, until July 14th, 2021. Can you explain for me why there was a year delay between when the defendant filed the second amended complaint, which would have triggered the district court's obligation under Rule 16, and when the district court finally got around to issuing a Rule 16 scheduling order?
I'm obviously not privy to the court's internal deliberations, so I don't have a clear answer for you on that. There was nothing communicated to the parties. Obviously, the pandemic was going around that time, but nothing was communicated to the parties. But that point goes to another issue.
And your client didn't reach out to the plaintiff for a Rule 26 conference, and the plaintiff hadn't reached out to you either. I'm not, it's kind of like the obligations on both sides. But that didn't take place until June 11th, 2021. So that's nearly a year after the pleadings were set that neither side reached out to one another to even have a discussion about a Rule 16 scheduling order. And so it's, dismissing a case is pretty severe sanctions. And I'm just trying to figure out, what was going on in that time period. Were the parties discussing this issue? There's something in the briefs about there were some discussions between the parties about trying to figure out what was wrong with these sirens, what was going on. Was that going on at the time, or what was going on?
The parties were in communication about certain matters, but not specifically about discovery. I initiated the discovery conversation, even though I am the defendant, and I never initiate that discussion. It's always the plaintiffs who want to charge forward. And I finally reached out and said, counsel, this case has been pending for almost a year.
As well you should have.
Yeah. And I said, we need to get going on discovery. The response I got was, well, the judge hasn't set a scheduling conference. And I said, well, I'm pretty sure the judge expects us to move forward with discovery anyways. And the response I got was a threatened motion for sanctions, as though I had done something improper by suggesting we should move forward with discovery 18 months into the case. So that goes to Daniel's talks about a lack of prosecutorial intent. I have no idea why Nextel waited that long to initiate discovery and then to suggest I should be sanctioned for suggesting we go forward with it.
Can you answer the question that I asked Mrs. Zara with regard to Robert Basil? He had clearly traveled to Saudi Arabia during the installation. And so I was trying to understand, what was it that your client was trying to obtain or overcome to try to do these inspections? Because I see that your client filed motions to compel the names and the contacts, but there was no motion to compel the inspection itself, right?
Well, this goes to the long tortured history of the case. In July 2021, when I finally got opposing counsel to talk to me about scheduling and discovery and things of that nature, one of the first things I said, as Judge Kirsch suggested, was we need to inspect these things, quite obviously, and they agreed. We do. Counsel, it was former local counsel Edwards said, I agree, and we had productive discussions because I was being led to believe. Remember, the allegation is that the government of Saudi Arabia rejected every one of these sirens, rejected all of them. And so I said, well, I assume Nextel, you must have all the sirens somewhere because the government rejected them. And I was proceeding under that assumption because I was led down that path from July 2021 through March 2022. The whole time we were having discussions, and I was led to believe that Nextel would be giving me access to test these sirens. Finally, in March 2022, local counsel Edwards drops out of the picture, and the other counsel pops in, and all of a sudden we get disclosed, we can't give you access to test the sirens. All of a sudden at this point. Well, how can that be? The government rejected them, I thought you said. Well, the government's got all of them. They've got complete control of them. So we say, well, that's the case. How did your expert get access to them to file a report in January 2022? You must have some inside connection. You can facilitate these. Help us do that. Wouldn't do it. And that's why we filed a motion to compel. Give us the names of the people you were talking to so we can at least write them a letter.
Did you consider filing a motion to compel the inspection itself?
It was basically wrapped up in the same motion. I mean, we discussed the issue, I believe, at the motion to compel hearing, that the shifting story is how do you go from saying the government rejected these sirens, so we must have them, to saying, well, now the government's got them. And this is 6 years later, by the way. Why does the government still have these sirens? So we were understandably confused and a little whipsawed, to be candid.
Why didn't American Signal move for summary judgment?
Well, a couple of reasons. We didn't have an evidentiary record because that was another problem with Nextel's discovery practices. They treated discovery like a one-way street, like they were allowed to unilaterally decide what material was discoverable. So for instance, one of the most egregious, we said, all right, Nextel, your claim is that the government rejected every one of these sirens. There must have been a reason. There were 750 of them. They were spread throughout Saudi Arabia. There had to have been reams of communications between the government and Nextel, who installed them, to explain why the government was rejected them. So we served some vanilla discovery. Produce all communications between you and the government so we can see exactly what the government was complaining about. Was it an installation issue? What were they upset about? Nextel, we're not going to produce those.
And I think they said they're not going to produce them because the district judge had found that the relationship between Nextel and the Saudi government was irrelevant to the case.
That was an offhand comment at a status hearing. That was not a formal motion hearing.
Now, I understand, but then what I find troubling about, I mean, there's lots of things I find just strange about how the proceedings were done here. But then the magistrate judge, on the motion, when looking at the motion to compel, then takes that stray comment and says, well, this is what the district court wants, and I'm not going to touch that. So you're right, which again kind of befuddled me. And so I'm just trying to make sense of this, looking at the record. And
Well, we objected to the magistrate's ruling, and I believe the trial court, as trial was starting to get closer and closer, as most trial judges do, started digging into the record, looked at the discovery practices, and that was why we got this decision that's referencing, we're going to do this through bank accounts, because that was another issue. The allegation was the government rejected these, we didn't get paid a penny for them, and okay, except for there's emails, or an email on the record that suggests that the government paid everything except for 2.7 million, which in their world, that's called retainage, it's a term of art, and it's 10%, which means the contract was 27, 28 million. So that suggests that they got paid 25 million or something along those lines. So we said, well, how can the government have not paid you anything, and yet here's an email from your own person talking about the only thing left that hasn't been paid is 2.7 million retainage, something along those lines. And I have a correspondence from their counsel that says the exact same thing, that they did get paid after they've been denying getting paid. So obviously we're not going to rely on their word. We can't trust a thing they're saying. We served discovery and said, let us see your bank accounts. Let's see, and if you want to put attorney's eyes only, that's fine. But we're entitled to this very basic discoverable information. Nextel, no, we're not producing it. And that's why I think the trial court by the end is referencing, we're going to look at bank accounts because there's some serious concerns here.
And could you, when I was looking through the docket, I noticed the discovery cutoff. The original trial date was October 24th, 2022, right?
Correct.
And it seemed like it says the discovery cutoff is 30 days before that date. Was that correct?
Yes.
And so the court didn't provide a summary judgment schedule. It just said your discovery is ending on day 1, we're going to trial on day 30, whatever.
The court's standard pretrial order, I may be using the wrong phrase, has a very detailed summary judgment provision in it that involves a lot of stipulations that the parties have to come to, and we weren't going to be able to come to one. That became clear. And it says you can't file a summary judgment motion if you don't have these stipulations.
And did the court ever give you a deadline to file a summary judgment motion?
I don't recall off the top of my head, although that may be addressed in the standard pretrial order.
And that's particular to Judge Stattmiller, not E.D. Wiss.
Correct, if I'm remembering correctly.
I mean, it's pretty difficult to file a summary judgment motion when discovery is closing 30 days before trial.
I would agree.
And from my experience, I haven't practiced in a while, but it just seems to me.
And I would agree. I see my time's up. So unless there are additional questions, we're asking that the court affirm.
Thank you, Mr. Harvey. Mr. Zahar, we'll go back to you now for a rebuttal argument.
Your Honor, there's one thing I want to address first. In that time frame after the amended complaint and the initial scheduling order, the parties were engaged in attempts to resolve the issues between the parties without going, too much further into those what was actually going on between them in that time. So there were those attempts as well. So it wasn't just the period of nothing was happening until July 2021. With respect to the sirens and their locations, they were rejected. But these sirens, they're not, sirens that are hanging where, for example, my lamp is hanging. They're on 70 to 100 foot poles. They're heavy. They're all around Saudi Arabia's eastern province. They're not in one local city. And the province spans thousands of miles. And they weren't removed from the poles. There's been every attempt by my client to try to resolve the issue with the sirens, to hand the sirens over to the government for final acceptance of the goods. The goods have been rejected by the government. The government, at the end of the day, wants working goods, and our client's goal was to get working goods, and that's how this lawsuit came to be. Another thing is with respect to the defendant going to examine the sirens, they've had an agent in Saudi Arabia since prior to the lawsuit beginning. This agent's helped them get send their bid into the government and to the plaintiff to produce and manufacture the sirens. So that agent could have assisted them in many ways. One way was helping them get their visas if they needed it. Another way was to help them get somebody to examine the sirens if they needed that as well. So they've had that individual there. The questions right now is, in this case, was the case prosecuted? And again, by the actions of the parties, we filed all of our documents that we believed were necessary for trial and that we believed, at least on the plaintiff's end, would prove our case in chief and prove our case. You know, we had all of our exhibits ready. We had all of our witnesses ready. We had all of our documents ready. We had the jury instructions sent. We had the jury verdict form sent. We had our pretrial report sent. We had our deposition transcripts that we were going to use as well. And those are all listed. And those were all provided to the court. So on our end, at least, you know, we were ready. And we believe the defendant was ready as well because they sent I believe it was over 600 exhibits as well. They sent in their proposed jury instructions. They had all their witnesses ready to testify as well. And for that reason, Your Honor, we believe that the district court abused, Your Honors, we believe that the district court abused this discretion in dismissing the case for failure to prosecute. And we respectfully request that Your Honors reverse the district court's dismissal and allow this case to proceed to trial. I see my time is up, Your Honors. I thank you for your time.
Thank you, Mr. Zahar. Thank you, Mr. Harvey. The case will be taken under advisement.
Thank you, Your Honors.
We will move now to Appeal 23-1082, United States versus Michael Carmel, and Ms. Ramey will move first to you.
Good morning, and may it please the court. My name is Colleen Ramey, and I am an attorney with the Federal Defender's Office representing Michael Carmel in this case. In this case, the law enforcement accessed Mr. Carmo's real-time cell site location information without a warrant. They knew that he was a felon. They knew that he probably possessed a firearm, and they knew that he was traveling to Kenosha, Wisconsin, shortly following a period of civil unrest. The litigation in the district court kind of took an unusual turn. As I was sitting here preparing for this, it seems like everyone sort of lost the forest for the trees. He filed a motion to suppress and a motion for a Franks hearing based on what the district court concluded were typos in affidavits about what the FBI knew at when. So if we kind of go back to the timeline here, we have a report comes in from a CI to the Waverly, Iowa Police Department, who then relays a report to Kenosha Police, who then relays a report to the FBI, who then asks AT&T for this information without a warrant. At some point, it appears clear in hindsight that the CI told the Waverly Police Department that, well, he said some people were going and picking people off and maybe looting, but more than likely, upon further questioning, she said, no, he didn't say he was going to do that. That turned into, somewhere along the line, he is intending to go and loot and pick people off. And that is the basis on which the district court found that there was exigent circumstances in this case and bypassed the warrant requirement. That is a material misrepresentation of the information that law enforcement possessed. And I think that the district court and the parties sort of got off into discussing what the specific FBI agent knew when he made that representation to AT&T. However, what really is at issue here is were there exigent circumstances that existed to support a warrant?
Why does any of that matter? after Hammond?
Your Honor, I believe that as I argued in my reply brief, that the government has waived their reliance on Hammond.
They can't do
and
that.
argument.
United States versus Cade says you can't waive reliance on a case like Hammond.
Well, Hammond was really cabined to the specific facts.
Which are
in
almost the
Hammond.
exact same as the facts here.
The facts aren't really developed here, and there is a specific difference in this case of the facts that we know were that Mr. Karma was in and around a hotel when they were tracking him. That is as much as I could find in the record.
Isn't that enough?
Well, that is afforded different protections than being on public roads. Like being in your hotel room is afforded protections more akin to being in your home, and in terms of privacy. And Hammond.
Okay, go ahead.
Oh, I was just going to
No,
say
go ahead.
Hammond really relied on the fact that that the defendant in Hammond was on public roads and in a parking lot. Now, yes, they did ultimately find Mr. Carmo in a parking lot, but they were tracking him for hours, and they were tracking his cell phone. It wasn't a beeper on his car. It wasn't something like that. They were tracking his physical whereabouts, not the whereabouts of his car or anything like that. And we just don't have a sufficient record to know where exactly he was during those times and whether or not it actually is distinguishable from Hammond.
If you were right that there should have been a Frank's hearing, does the exclusionary rule even apply?
I mean, if there was no...
There's no warrant.
If there's no warrant and they did not have a good faith basis for relying on this information, then...
What law says that? There's no warrant, okay?
Right.
So does the exclusionary rule apply to the Act, to the Stored Communications Act?
Because we've got the statutory,
Right.
2027, then we've also got the constitutional case law with regard to exigent circumstances.
Exactly.
Right. So I think I'll let Judge Kirsch follow on.
Yeah, under the Act, does the exclusionary rule apply?
No, it would apply under the Fourth Amendment.
Okay, so there's no, your argument is that because there's no exigent circumstances,
Correct.
that they needed to get a warrant.
Correct.
So disregard the Act altogether.
Well, the Act imputes exigent circumstances, right? The Act specifically says you can access these under exigent circumstances. So if there are no exigent circumstances, they can't rely on the Act, and they would need a warrant.
But
then
what's the argument here that there's no exigent circumstances?
The argument
based upon the facts that the police officer knew, even if the facts were slightly wrong.
The argument is that they didn't have, they relied on this motive that had been ascribed to him. So the facts that they knew and had gotten from the CI were just that he was a felon traveling to Kenosha and probably had some firearms.
Well, I thought it was more than that, though. I thought there was shooting involved. The issue was who was going to do the shooting, and what was the evidence regarding the shooting?
The evidence that was in the Waverly Police Department's police report was that he said he had allegedly told the CI that some people were, looting and shooting. And then when pressed, presumably when pressed, I'm inferring that, she said, no, he didn't say he was going to do that. I mean, President Trump was visiting the area. He was probably going. It could have very well been that he had, an interest in self-defense.
I mean,
right?
It could have been. Yes,
sure.
Could have been.
No, but the point is that there is this motive ascribed to him that she expressly disclaimed.
I'm sorry, go ahead.
Counsel, what troubles me about your argument is that Frank's, as Judge Kirsch kind of, I think, alluded to, deals with warrants, right? And affidavits. And we're not talking about warrants here. We're talking about whether there were exigent circumstances and also whether there was a good faith basis under the Fourth Amendment, we talk about good faith and whether the officers had a good faith basis to believe there were exigent circumstances. And under the Act, we're looking at the provider, because it says the provider in good faith believes that the emergency involved danger of death or serious physical injury, right? And so Frank seems like an odd fit here.
I agree with that, Your Honor.
And so I can see where you can make the argument to a district court that perhaps some additional inquiry needs to be made to test whether or not the good faith was a reasonable good faith, right? And so we should hear from the officers, kind of see what they did, et cetera, et cetera. But Frank also makes the burden tougher on you as a defense counsel, right? And so what are we to make of the request for a Frank's hearing in a situation like this?
Right, and this was a motion to suppress and for a Frank's hearing, I think, because there is this suggestion that the law enforcement has to present the provider with exigent circumstances, and that was the crux of the problem here, right? That was the misrepresentation. So it feels like a Frank's hearing because the provider is sort of taking the role of a court in deciding whether or not they're right. And so I think that's how we got into a Frank's discussion in the district court, not being the attorney who litigated this below. And that's how we took this sort of turn, because we're sort of in this middle ground between those two.
Maybe it's just better characterized as a request for an evidentiary hearing.
Yes, I think
right?
that's
with regard to good faith.
Right, and whether or not the officers, as a whole, were relying on good faith, were acting in good faith.
Right.
You may reserve the rest of your time. Thank you, Ms. Romay.
Thank you, Your Honor.
We'll give you a little bit more time than that. Don't worry. Mr. Proctor, you're next on behalf of the government.
Thank you, Your Honors. May it please the court.
Mr. Proctor, I take it that the government wouldn't have a problem if a district court in a situation like this, if district court had some serious concerns about the underlying motivations of the officer, decided, you know what, I think we're going to do an evidentiary hearing to figure out exactly what was going on that led to the request to the provider. I take it that as a general rule, that sort of procedure is not something the government would have the government wouldn't object to a district court within its discretion having an evidentiary hearing like that.
If the facts presented called for, there was a material issue of disputed fact that required testimony to resolve, I think the government would be obligated to, that's okay. In this situation, though, Your Honor, the facts that were at issue were resolvable on documents. They were laid out, and the district court was able to, it just had to do with how to interpret those documents. The district court looked at those documents and was able to determine that it could resolve it. There was a clear typo. They resolved exactly when the FBI received certain information, when the Waverly written report was produced. That was all able to be resolved without testimony, and the district court, therefore, did not see it required to do that.
Mr. Proctor, the way I understand your argument here is there's no search. Fourth Amendment does not apply.
Yes.
We're not in Fourth Amendment land at all. We're only proceeding under the Act. Right? I want to put if Hammond applies, right, the Fourth Amendment does not apply here, and everything occurred under the Act.
Correct.
The exclusionary rule does not apply to the Act.
Correct.
Right? So if the officer made a misstatement under the Act, right, and there's no Fourth Amendment search, and there's no exclusionary rule, the misstatement doesn't matter. And under our reasoning under Hammond, that makes sense because we say it's not a Fourth Amendment search. It's just information to which anybody could have had access.
Your Honor, I agree with that. If there's no Fourth Amendment, then suppression is not a remedy, and that's made clear in the SCA.
That's the end of it.
There are
case.
Yeah, but and In case there's a concern about guardrails, if an officer is found to be misstating facts, that is going to seriously impact that officer's career. Judicial
Right, I mean,
findings.
these are, I assume these are just like affidavits that they're presented on, I don't even know any, I don't remember anymore. Under the Act, is this information presented under oath?
No, it's not necessarily presented under oath. It is, there's no requirement under oath that it be presented under the Act. It is up to the provider to be convinced, or I'll step back a second. The law enforcement could simply tell the provider, we have exigent circumstance. It is up to the provider to decide if that's enough or they need more to release information under 2702C4. Here, there was more of a statement made, but there's no standard as to what law enforcement needs to tell the provider to convince them to release.
And of course, the law enforcement officer can have more problems if there was a situation where the Fourth Amendment does apply. Let's say the law enforcement officer was seeking information to track the defendant in his or her home. The whereabouts, we want to track his cell phone, which he has in his pocket, because we want to see from what room to room he's going to see if there's drug activity going on. Whatever the case may be, right? See if there's other people in the house. Whatever the case may be. There, the Fourth Amendment may apply.
I agree with that, Your Honor. Under cases such as Supreme Court in Carroll, where there's a tracking device that was sent for the purpose of seeing where a certain item was moving within houses. That if that's the purpose, yes. Where we're only looking to locate a specific person, I think that's a different situation.
Which is here, which may have been even if the officer made a mistake, and clearly there was a mistake made. Even if the mistake was made, even if it was a dishonest mistake, here the officer just kind of gets lucky because it doesn't matter, because the Fourth Amendment doesn't apply, right? And the Act does not provide for exclusion of evidence.
I agree with that.
That's the end of the case.
Yes, the government agrees with that.
Even though there may be a gap.
Yes, Fourth Amendment doesn't apply under Hammond in this case. Suppression is not a remedy. I agree with that. And I want to kind of set the stage as well, Your Honor, that overall, the police did good work here. They acted quickly to stop and identify a seemingly dangerous person who was illegally transporting weapons to the scene of recent riots. Once he was located, evidence was there.
Is that enough for exigent circumstances?
For exigent circumstances here, Your Honor, I can parse that out more. Here, one thing that...
Okay, let's take the statement, put the statement to the side, okay, dispute about the statement. We have an area where there's rioting going on, and there have been shootings in the area. And so law enforcement learns of a felon who is going to that area from out of state with guns, okay? With lots of guns. Is that enough for exigent circumstances?
It could be. And I think that cases, we can look at cases where, in Rosario, for instance, where the court found that there was good faith belief in exigent circumstances where somebody was transporting or had stolen a number of guns. Guns can be, in certain circumstances, an exigency, especially, and I think in Huddleston, the court had mentioned that if there's a likelihood that a gun is going to be used, in that case they had a violent felon trespassing in a home, and that was a breach of a home. The court found that gun can be exigent circumstances. Here, on top of that, Your Honor, we have text messages that Mr. Carmo sent to the source on his way to Waverly with a picture of himself holding guns and then another picture with a AR-15 type rifle with a large drum that he calls the game changer. The only reference that he's making to that is what he is going to do in Kenosha. He is going to change the game. That is the only reasonable inference to take from that. That adds on top of just merely possessing guns, which the source said were machine guns that he had. And again, and at the time that the FBI and law enforcement in Wisconsin received the information from Waverly, they knew that Mr. Carmel was likely already in Kenosha or somewhere close. They needed to act fast. I think it would be almost absurd to think that they would not act on this, would not consider this exigent circumstance, that this was a person that they needed to locate. And what they did to locate him was get this exigency ping or location information. It's a minimally intrusive way of trying to locate someone. They found him in a public parking lot. They did not breach a home. They did not even breach a hotel room based on a warrantless on any warrantless activity. The breach of the hotel room later came from consent by Mr. Carmel, and as well as the search of his vehicle. There was later search warrants executed at his residence and again at the hotel. Your Honors, unless there's any further questions, I'm happy to rely on my briefs and ask that the court affirm.
Thank you, Mr. Proctor. Ms. Romay will give you 2 minutes for rebuttal.
Thank you, Your Honor. Just one quick point. Everyone operated below as if the Fourth Amendment applied. This issue was relevant. It was out there. Everyone was aware of it. The government expressly declined to argue that the Fourth Amendment did not apply. And then when Hammond came, and then there are facts that were not developed in the record that would decide, would be material to deciding whether or not Hammond controls. Hammond explicitly said that, it emphasized that law enforcement used the real-time CSLI to find Hammond's location in public, not to peer into the intricacies of his private life. It said the facts did not suggest that law enforcement used either the real-time CSLI or the beeper to examine the defendant's movements inside of a home or other highly protected area. In this case, we know that Mr. Carmo was inside the hotel room because all of his, after they searched it afterwards, he had belongings there. They monitored him for hours and only approached him once he was in a parking lot. So presumably at some point during the parking lot of the motel. So presumably at some point during their monitoring, he was inside the hotel room, and that is afforded more protections. We just don't, that wasn't ever developed in the record because the government expressly chose not to pursue that argument. For these reasons, we should, this case should be decided about exigent circumstances.
Thank you very much, Ms. Romay. Thank you very much, Mr. Proctor. The case will be taken under advisement. We'll now move to Appeal 22-2833, Christopher Rolson versus John Noble. And Ms. Myers will begin with oral argument from you.
Your Honors, Counsel, and may it please the Court, my name is Claire Myers, and I represent the petitioner, Christopher Rolson. Mr. Rolson's Sixth Amendment Confrontation Clause rights were violated when the state introduced the testimony of a substitute when the state introduced the testimony of Ryan Gajewski, the original DNA analyst, through the testimony of a substitute analyst, Carly Leader. Leader testified as to the procedures Gajewski followed, the observations he made, and the professional judgment he exercised in creating his certified formalized report. Clearly established Supreme Court law prohibits the admission of such testimony, and the Wisconsin State Court's decision was contrary to this precedent when it held otherwise.
Ms. Myers, are there certain questions that you think counsel would have posed to Gajewski that could not be asked of the subsequent expert, Leiter?
Yes, Your Honor.
What would those be?
Of course. The record in this case actually provides an excellent example of the questions that could have been asked if Gajewski had taken the stand. So on pages 301 to 304 of the separate appendix, Leader testified as to the processing of the bar stool, which was one of the weapons that the state used to pin Rolson and not Davis to the crime. She testified as to that the bar stool was first screened for bloodstains, that an analyst can determine whether to swab multiple areas of an item, and that was done in this case, that different stains were selected for a DNA analysis. And she also testified that Gajewski, who had done the processing for that item, had opted to use YSTR DNA analysis rather than autosomal DNA analysis. So if we can compare that to Leader's testimony about an item that she did process, a pair of rubber gloves, she provided very similar testimony. She was able to describe how that item was swabbed and whether any blood was detected. During cross-examination, and this starts at page 308 of the separate appendix, Leader was asked about her testing of the rubber gloves, since she had actually performed that analysis. And she was asked what areas she swabbed, whether blood was detected or not. Then defense counsel tried to ask her about the processing of the bar stool, and she responded that she would have to review the report because she was not the one who had processed it. It's exactly that kind of question that Melendez-Diaz guarantees that a defendant should be able to ask.
He had the ability to ask, and the answer may well have helped the defendant. I guess, how do we distinguish this case? In criminal cases, for instance, very frequently agents will testify based upon another agent's report. The chemist comes to mind, the DEA chemist. If a defendant challenges the weight or the makeup of a particular drug, a chemist who may have left the DEA's employment years ago or may not be available to testify on that day, the government just gets another chemist who testifies that I reviewed the report. Here are the steps that chemist took. They were the same steps that I would have took, and I adopt the report and the findings of the report as my own, even though I wasn't the one to perform the particular test. And then that is what's subject to cross-examination. Why is that not enough here in the DNA context as well?
Thank you, Your Honor. So Bullcoming prohibits the kind of testimony that describes an analyst, the procedures that an original analyst follows when those procedures reveal the analyst's independent judgment. In Melendez-Diaz, the court described that the testing in that case, which I believe was a gas chromatograph, involved several steps. It was a specialized process.
But hold on for 1 second. I think the difference here, the difference that I'm trying to capture is when an agent cannot testify, an expert cannot testify that that's someone else's opinion, right? That's what I think it was. Bolingbrook is the name of the case, or Bullcoming says you can't testify that that's someone else's opinion. But our cases hold you can adopt the opinion as your own and testify that I reviewed the reports, I reviewed the manner in which the testing was done, and this is my expert opinion. And now I am subject to cross-examination. Isn't that what happened here?
Your Honor, the court's decision in Bullcoming is a bit different. It did not hinge on whether or not the substitute analyst introduced the conclusions of the original analyst, but rather on the fact that what the substitute analyst, or what the surrogate witness was introducing was the human interpretation contained in the testimonial statements of the report. And so
I agree with you. Isn't that a problem for you?
So in this case, Your Honor, we really are drawing the distinction between raw data, which is not covered by the Confrontation Clause and which an expert may rely on to reach independent conclusions, and the kind of human analysis that Gajewski performed in this case that Leader did not simply rely on, but also testified to in this case.
But Ms. Meyer, is that seems like a very difficult line to draw, right? Because when you're looking at raw data, raw chemical data, someone, right, is processing that data. Very often, it's not very often that you can just put a glove into a chromatograph and have something come up, right? Someone, besides the sampling, when that sample is given to a lab, someone at the lab, right, is diluting the sample, it's processing the sample, making sure that the slides are properly made, choosing which slides to test, right? All of that is kind of human interaction. And so how would you, it seems like that line between raw data and anything that would require human interaction, that line doesn't seem like a very meaningful one, because even processing raw data, there's human interaction and trying to make sure that the tests are done correctly.
Thank you, Your Honor. So while that line might be difficult to draw in an edge case, this case falls very squarely on the side of the line of human analysis. So in this case, Leader testified as to certain discretionary decisions that Gajewski made, and the defense counsel was not able to cross-examine those discretionary decisions. There's also observations contained in the report that only Gajewski could be cross-examined about, not Leader. For instance, that there were stains on certain pieces of evidence, that there were, that there was enough DNA to take samples of certain pieces of evidence and not enough to take samples of others. So while discretion might be implicated in other, forensic analysis that was done, I think the distinction here would be not only was this human analysis performed and memorialized in the report, but also that Leader testified as to it, not merely relied on it to form her independent judgments.
If I could ask you a question about the clearly established federal law. I mean, as you undoubtedly know, the Supreme Court just granted cert in Smith v. Arizona, which kind of addresses what I would think is a very relevant question here, right? Whether the Confrontation Clause permits the prosecution in a criminal trial to present testimony by a substitute expert conveying the testimonial statements of a non-testifying forensic analysis, right? On the grounds that the testifying expert is offering some independent opinion, and the analyst statements are offered not for their truth, but to explain the expert's opinion, and the defendant not independently seek to subpoena the analyst. Isn't that really the question we're dealing with here? And if the Supreme Court thinks it's so unsettled that it has to grant cert in this case, what's the basis of your argument that it was clearly established that that the defendant here had a right to confront the underlying original expert?
Of course. So in Smith, the petitioner asked the court to address two questions that Williams expressly left open, and that's whether, well, the first question is whether facts underlying an expert witness's opinion, what sometimes is called basis evidence, is offered for its truth. And the second question is whether the Confrontation Clause is satisfied when the defendant has the opportunity to call the original analyst. So neither of those questions is implicated in this case. This case is squarely decided by Bullcoming, which is not at issue or at risk of being overturned by Smith. And that's that distinction between this raw machine-generated data and the human analysis that was contained in Gajewski's report, and to which Leader testified.
Thank you, Ms. Myers. We will be giving you some rebuttal time.
Thank you.
Thank you. We'll now move Ms. Burgundy to you for argument on behalf of the state.
Thank you. May it please the court. My name is Sarah Burgundy. I'm an Assistant Attorney General from Wisconsin, and I'm representing John Noble. Just want to clarify, Leader testified to her own opinions and conclusions that she based on Ryan Gajewski's data and notes, to the extent that Rolson is arguing that she entered his report through her testimony is incorrect. The report was never admitted into evidence. She never referenced the report It happened that her conclusions agreed with the report, but that was to be expected as this already went through a peer review and was produced in a report by Gajewski. There is really no clearly established U.S. Supreme Court law holding that the Confrontation Clause prohibits what happened here. We have a qualified DNA expert analyst. She did a technical review of data and notes produced by another analyst. She reached her own opinions and conclusions. She testified to those opinions and conclusions, and she never referenced the original report and was fully cross-examined by the defendant. And because we are in habeas and subject to AEDPA, that's the start and the end of this case. There's no clearly established law holding to Rolson's position. And in fact, if his position is correct, there's effectively no way to admit DNA evidence if an original analyst who does the testing is unavailable to testify.
Ms. Burgundy, we have kind of an interesting chain of case law here. You've got the Luther Williams case from Wisconsin, then you've got the U.S. Supreme Court case, Williams versus Illinois, then you've got Deadwiller. And Deadwiller is interpreting the U.S. Supreme Court case, which is a fractured opinion, attempting to discern where Wisconsin's law on Confrontation Clause follows after the Supreme Court case. What if we were to find Deadwiller to be less than fully accurate? If we were to read that opinion as not accurately reflecting what the U.S. Supreme Court did in Illinois, Williams versus Illinois, how would that affect the analysis?
You would still have to look to the United States Supreme Court law to say, okay, well, the Court of Appeals got it wrong, or, Deadwiller is wrong. It's wrong for them to rely on it. But we still have to look at Williams, Bullcoming, Melendez-Diaz to see if the Supreme Court has clearly established that what happened here is a violation of the Confrontation Clause. And I think as a matter of as a rule of thumb, I think if you're trying to rely on Williams from the U.S. Supreme Court as clearly established law, that's difficult. I mean, even in the multiple opinions in that case, the justices noted that they were not clearly establishing the law. And as Judge Lee mentioned, the Supreme Court's currently deciding the issue now, which I think underscores that it's not clearly established. And to the extent that you might think Wisconsin got it wrong in Deadwiller or Grip or Barton or any of the cases interpreting that law, I think many of the disagreements in these cases have come to why the Confrontation Clause does not bar this evidence, not whether it's violates the Confrontation Clause. So, and that's displayed in Williams. In the main opinion, there was the question of whether it was offered for the truth. Justice Thomas said it's not testimonial. There's also a question of whether it's a primary purpose. So there's a lot of different ways to get there, but ultimately the Supreme Court has never said that this can't come in. I wanted to just touch on the harmless error argument, which you absolutely do not have to reach because there's no clearly established law. But I think it's helpful to point out that Rolson relies pretty heavily on the state's opening and closing arguments to the extent they mentioned the DNA. But if you look at Rolson's closing argument and how heavily that counsel talked about DNA there are a number of points in the DNA evidence that actually supported his position that Davis, his co-actor, was the murderer and not him. Whereas the state's case was really primarily based on the two witness statements from Davis and from Walzak that were eerily similar. Both talked about how Davis and Rolson went to a house before going to the victim's house, and that a motion light came on and they moved on and went to the second house. And then Rolson's comments that he made about God not being there while he was stabbing Rosak. And other evidence all established that Rolson was in the house. Really, the only question was who stabbed the victim. So, unless the court has further questions, I'm willing to rest on the briefs and ask that you affirm.
Thank you very much, Ms. Burgundy.
Thank you.
Ms. Myers, we'll turn back to you for rebuttal, and we'll grant you 2 minutes of rebuttal time.
Your Honors, I just wanted to address one point in rebuttal. And that's the question of harmless error. In order for this court to hold that the state court's error was harmless, it must be convinced that the error was harmless beyond a reasonable doubt. And as Jensen v. Clements tells us, the standard is not whether the state could have proved its case otherwise. The standard is whether the evidence that was erroneously admitted had a substantial and injurious influence on the jury's verdict. And here, the record reflects that it did. The DNA evidence provided a crucial link between Mr. Rolson and the knives and bar stool, evidence that was supported otherwise only by the testimony of Austin Davis, who had every reason to point the finger at Mr. Rolson, and a witness who, although she claimed to be a good friend of Mr. Rolson's, was not present at the scene. And it is well documented that DNA evidence is powerful to juries. Under these circumstances, the state court's error could not have been harmless.
Well, thank you, Ms. Myers, and we want to thank you and Mr. Scadro and on your firm for taking the case and for your excellent advocacy. Thank you as well, Ms. Burgundy, for your excellent advocacy. The case will be taken under advisement.
Thank you.
Thank you.
We request that the court deny the...
Very good. Thank you. We will move now to our final case of the morning. This is Appeal 22-3278, United States versus Eunice Sally. And Ms. Ramey will again turn to you for argument on behalf of the appellant.
Thank you, Your Honor. Good afternoon now, Your Honors, and may it please the court, counsel, Colleen Ramey on behalf of the defendant appellant in this case. The decision to proceed without counsel must be knowing, voluntary, and intelligent. There's always a presumption against this waiver, and courts are directed to specifically spell out the dangers of proceeding pro se. That did not happen in this case. Particularly when that doesn't happen, we look at 4 factors to consider whether or not the decision to proceed pro se was made knowingly, involuntarily, and intelligently. We look to the court's formal inquiry into the waiver. We look to other evidence in the record, the defendant's background and experience, and the context in which the choice was made. In this case, there were many hearings, and I could not find a formal discussion with the defendant about this decision. There was certainly some discussion here. The courts didn't, neither the district court or the district judge nor the magistrate judge specifically spelled out the dangers of proceeding pro se, aside from it would be a lot easier for you if you had an attorney.
I mean, the district judge basically begged her
begged her to
get an attorney, or to say yes.
Sure.
Right?
Yeah.
I think at one point the judge said, all you need to do is say yes.
Yes, but there wasn't, and so certainly encouraged. Yes, I would absolutely agree that he encouraged her multiple times to get an attorney. There wasn't really this discussion, as you know, the bench book has all of these ideas of things that the court should say, and there wasn't a discussion of, do you really understand what the consequences could be? Do you understand what you're facing? Do you understand the penalties? In this case, the defendant actually is in a pretty unusual situation of, when you look at her background, while she has a conviction for a traffic violation and got, I think, probation, she had some really serious charges lodged against her, like murder, that was dismissed, or she beat any of the other charges that she had against her. And so, unlike, that's one of the factors that we look at and say, oh well, maybe she did have an appreciation for the seriousness of what she was facing.
Do we know, Ms. Ramey, in those situations whether she was in sovereign citizen mode or not?
That I have no idea. Okay. No, that is not in the record. And absolutely, she was presenting these sovereign citizen arguments, and so I certainly understand the court's challenge with that. She did, however, like in February of 2020,
say, yes, I understand the court has jurisdiction, and then she sort of just stopped participating. She really went back and forth. She expressed a desire for counsel, but there were several times where she said, yes, I'd like counsel, but I don't trust this guy. Like, she didn't trust Mr. Herman, the standby counsel from the defender's office. And that was really the option she was given, was, him, or, or you can hire your own attorney, which I'm not sure she could afford, but she did express at some point, she couldn't find an attorney while she was incarcerated in pretrial detention.
Sometimes in our case law, metaphors work, sometimes they don't. The metaphor that is often raised in Ferretta is the razor's edge.
Sure.
That the district court could have a problem if they did either thing. Mm-hmm. I take it your argument, Ms. Ramey, is the problem that Judge Dow here was a lack of a formal hearing. Is that because if he doesn't recognize her right to counsel, he's stepping on that. If he forces a lawyer down her throat,
sure, that's
a problem as well. So he's got to juggle this.
Right. And yes, I would agree with that, Judge Brennan. There wasn't really this inquiry into it, and I recognize that the case law says that there is not a text. There's not a specific colloquy that we have to have, and there are situations where a formal hearing is not required. I think in this case it would have really solidified this decision, especially based on how many times she sort of went back and forth. It wasn't exactly unequivocal. She looked at, she expressed a desire, and then she kept asking the court to represent her. I've seen a lot of sovereign citizen stuff, and that's the first time I've seen that. So there was a lot of confusion, and I couldn't say that this was an unequivocal, affirmative, and knowing. And that's, I think, really the crux of this, is that there just didn't seem to be a lot in the record to show that she was making this intelligent decision.
She was certainly intrepid. She didn't speak during the entire trial, right, as far as we could see in the transcript. There was one instance when the federal defender did speak up and say she needs the exhibits back in her cell. Mm-hmm. Other than that, though, the transcript just says she
did not participate.
Yeah.
Yeah. And then it seems like then as the government pointed out, at sentencing, she ultimately decided, actually I do want him to represent me. And I don't know what was going on in her mind. I don't pretend to know if that was all of a sudden the full consequences. She understood the full consequences of those decisions or not.
Which is different because she was incarcerated up until that point.
Yeah. Yeah. But now she was facing a lot of prison time after conviction, I suppose. So, if there are no other questions, I'll reserve the remainder of the time.
Very good. Thank you, Ms. Ramey.
Thank you.
Ms. Cook, we'll now move to you for argument on behalf of the government.
Your Honors, this is a case where the district court bent over backwards, as Judge Lee said, basically begged the defendant to make the choice that was in her best interest and accept counsel. But it recognized that it could not, to use Judge Brennan's phrase, force a lawyer down her throat, and that it had to respect her invocation, which was unequivocal and steadfast, to represent herself. As to whether the request was unequivocal, I'd point to two very clear points where the defendant unequivocally requested to represent herself. The first is the first time she is before Magistrate Judge Valdez, and she introduces herself. Mr. Meyer from the Federal Defender Program gets up and says, I've spoken with the defendant, and she does not want the assistance of our office or any other attorney. And I'm sure your Honors have looked at the transcript. This is not a defendant who is shy about jumping in when she believes someone has said something incorrect. She repeatedly jumped in during that hearing to say, no, that's not right, that's not what I want, you've forgotten this fact. She doesn't say anything about not wanting an attorney, and then proceeds to engage in mostly sovereign citizen rhetoric, although when a point is salient to her, she's able to have a totally normal conversation. For example, when she wanted to be released from custody and not subject to the strip search policy. There, the sovereign citizen rhetoric drops away, and she's conversing with the magistrate judge like a typical litigant. And indeed, the very next day, when there's a detention hearing, Judge Valdez says, you're engaging in sovereign citizen tactics. Your beliefs don't allow you to acknowledge the jurisdiction of the court. That's part of why I think you're a flight risk and you need to remain in custody unless you can post bond and get a third-party guarantor, or a third-party custodian, because you're engaging in these tactics that suggest you're attempting to obstruct the proceedings. But to move to the other point at which she unequivocally asserts her right to counsel, it's the first time she's in front of the district court. And the district court says, based on what you said to the magistrate judge, I understand that you want to represent yourself. And she says, that's correct. And I think the judge sort of realizes, I should be a little more explicit than that. You want to represent yourself? To which she says, yes, Your Honor, correct. And I think that's sort of open and shut on that. That's exactly the sort of unequivocal response that this court has requested and encouraged urged district court judges to push for. And in cases like Abbott, this court has said, when you have something that is as straightforward as that, that is unequivocal. I want to quickly address the times at which the defendant referenced some sort of desire to seek counsel. And I think it's important to point out that at no point did defendant say that she wanted the district court to appoint her a lawyer. What she requested twice was to be released from custody so that she purported to have an interest in seeking a lawyer, and both times the district court said, no, I'm not going to release you from custody. You can seek a lawyer from prison, you can use letters, you can call, but factually, I'm making a factual finding that you can get a lawyer in custody. But also, and every time, without fail, every hearing, this judge is reminding her that if she's indigent, he'll appoint the federal defender. She just needs to fill out the form, and he'll appoint the defender. For many of the conversations, there's a defender in the room. From the beginning, really through the end, there's an attorney, and the district court says, this is an excellent attorney, 2 different attorneys. These are excellent, experienced attorneys. Take them. And eventually, to Judge Lee's point, the district court sort of gives up on requiring her to prove she's indigent and says, just say yes, and I'll appoint this great lawyer for you.
It would have been nice if the district court would have reminded her of the potential consequences of being convicted in this case, right? Maximum of 20 years, right? And kind of went and told her about, talk a bit more about the consequences, so that the record would be more, might be more complete with regard to a knowing waiver of the right.
I agree, Judge Lee, but I think it's important to point out that in this case, she was informed of the charges and the maximum penalties because Magistrate Judge Valdez had the government attorney who was present read her that. And indeed, when she refused copies of the indictment repeatedly, the judge said, fine, I'm going to have counsel for the government read you every line, every word of this indictment. And they did, right at the hearing. Read it right into the record to her so that there could be no question that she understood. Because, as the district court said repeatedly, she was engaging in obstructive tactics. And I heard my friend on the other side say, at some point she just stopped. And I think that it's not that she just stopped. Her behavior always stayed right on the line of being allowed to continue to represent herself while being as obstructive as possible. I think it bears pointing out that, she, at one point she stopped coming to hearings. She refused to be transported. And after that happened several times, I think it was 4 hearings, the district court said, I'm appointing standby counsel for you. And if you continue to refuse to participate at all, if you will not show up, then I will appoint him as full counsel. You have to show up. immediately she begins showing up. There was, she would physically, one time she refused to put on the headphones when she was at the MCC, and the transcript, the marshal's saying, I don't understand what's going on, we can hear you, the headphones are working, she physically won't pick them up and put them on. They start having hearings again in person, and she'll appear, but she will not speak. And the judge says, okay, you have your right to stand mute. That's well established in this court's cases like Jones that was recently decided by this court. You can just stand there as a form of sort of silent protest or put the government to its case if you want. But if you're disruptive, which the court thought was a real possibility, this will be like Brock, this will be like Banabe, and if you become obstreperous and you disrupt the proceedings, standby counsel is gonna have to step in. And she stays on the side of the line. She says, okay, I'm gonna not participate, but I will physically appear, and I will not be obstructive. Same thing happens again at sentencing, where she refuses to be transported again, and after a couple of tries, she refuses to respond to the direct questions from the district judge at a hearing about her sentencing. And finally, the district judge says, I'm not gonna make the marshals, I'm not gonna authorize force like I did at trial. If you don't come, we're gonna sentence you in absentia, essentially, and you'll be deemed to have waived your presence at sentencing, which she's entitled to do. And once it becomes clear sentencing is going to happen, she says, oh, okay, and she comes to court to do her sentencing. And indeed, at that point, even after her efforts to represent herself at sentencing when it comes to the PSR are unsuccessful, then she hands things over to standby counsel and says, I'd like him to speak for me on the 3553A. And I mean, counsel says, yeah, we had conversations, I was prepared to step in if that had happened. So I mean, I don't think there's any way, looking at this record as a whole, that this court can see anything other than an unequivocal waiver, a persistent desire and an informed desire to represent herself, and a bench that worked incredibly hard to allow her to pursue the constitutional rights that she wanted to avail herself of. If this court has no further questions, I'd ask that you affirm.
Thank you, Ms. Cook. Ms. Ramey, rebuttal. The only question would be, is there anything in the record early on about any assessment or evaluation for not guilty by reason of mental disease or defect? Or
I saw nothing of the sort. And she, again, wasn't represented by counsel even at the beginning. And so that would not have been, that's typically brought up by counsel.
Right. Thank you, Ms. Ramey. Thank you, Ms. Cook.
Thank
The case
you.
is taken under advisement.
Thank you.
That will complete our hearings for the day, and the court will be in recess until tomorrow.